So, hello everyone. This is Patent Effect Podcast. So, welcome, and this is the second session of the second season of the Patent Effect Podcast, and I have very distinguished guest today from Munich, Germany, Bastian Best. How are you, Bastian?
Hi, Mustafa. I'm fine. Thank you. Thanks for having me. I'm looking forward to the conversation.
I'm really happy that because we had already a discussion with another seminar with you with the LAS International and LAS Turkey. So I saw that your background, your knowledge about the patenting of digital innovation is great. So you are really good at expressing the details of this topic. So I really thank you for making easier this topic.
Thanks so much. Yeah, it's amazing to for me every day myself. I have to say because I mean at the end I guess I'm just a computer nerd, so that's why I became a patent attorney and focusing on the digital space in the first place. But being a computer guy, also my second, I guess, my creative outlet besides the attorney job is really doing all sorts of online stuff. Ever since I was building little WordPress blog pages and things like that, and more recently than even video stuff. And right now with my new firm now for 6 months, both kind of comes together
Yeah,
into
exactly. Maybe we can
the whole
we
thing.
can start with knowing you. So who is Best in Best? So maybe you can say to the audience or your background or your previous companies. So and what are you doing now?
Yeah, so Bastian Best, I'm a European patent attorney, European and German patent attorney. I live in Munich, in Germany, where I was born and grew up, and I'm still here today. Originally I started, as I said, I was a computer guy all my life, so studying computer science was the only option for me, basically. After my studies, I first of all I started working in the automotive industry for a couple of years at one of the big Bavarian automotive brands in Munich. You may guess which one. And then after 3 years, I kind of asked myself where my journey should go, and then somehow more or less by accident I got to know what the job of a patent attorney is and what patent attorneys do, and it struck a chord immediately with me. I don't know, and then at some point I just quit my job and just applied for the education to become a patent attorney in one of the big law firms. Barlele Pagenberg, I worked there for 13 years, including 5 years as a salary partner. And yeah, now since pretty exactly 6 months, I started my own firm, which is fully digital. So my overall slogan is patents for the digital future. And this goes in two ways. I help companies only with patents, only for digital innovations, and also my little solo firm. Right now, I'm just a solo practitioner, is operating fully digitally.
Perfect, perfect. So you're just focusing on digital innovations. We can say that
Hmm.
computer implemented
Yeah.
inventions. So our topic today in our podcast session will be on discussing the importance of protection, patent protection on digital innovation. So we can
Hmm.
start with uh, discussing about what is digital innovation. So what is the real meaning of digital innovation and digital patents? So and then we will come through to the definition of the computer related inventions in the law.
Hmm.
So we can
I
start on that
see.
point.
What is digital innovation? Yeah, that's kind of a tough one, I think. So I don't have any, let's say, academic or exhaustive definition at hand. Really, what I can say for sure is that digital innovation is messy, for sure. Uh, let me just make an example. So yesterday I had what I call an invention mining workshop with one of my clients, SME from Germany,
Mhm.
and they are doing digital innovation in the sense that um, they do digital signage, which means their customers are, let's say, supermarkets or shopping malls, so very brick and mortar in the real world, businesses. And my client, the company, um, puts up displays there
Mhm.
in order for the, let's say, the shopping malls to connect the analog and the digital world, so you can do basically online shopping. You can interact with those screens with gesture control, things like that, gamification aspects. So that's really one example where, which for me is so interesting, because the analog, the real world, and the digital world kind of melts together here. And that's the business of my client. And now, of course, they ask themselves, well, can we protect that business model, these products somehow? And here it gets really messy, because you have the full spectrum, basically. You have the hardware devices which they are delivering and maintaining and selling. You have the content that needs to be programmed and run on the hardware, on the displays. They have the whole cloud server architecture uh, on the back end, because my client operates the content for possibly thousands of supermarket branches. So you have the full spectrum: hardware, software, locally in the cloud. So, and there are multiple uh, uh, points where innovation can happen. But and that's the problem why it is so messy, because it's all in the cloud, to say it literally. So you don't really know where the boundaries are. I think that's one big difference between, let's say, mechanical engineering inventions. When you innovate in mechanical engineering, you most of the time you have a product on your table. You can have a prototype, you can look at it, you can put it on your table, inspect it from all sides, tear it apart. And with digital innovation, it's all in the cloud. You don't know where the boundaries are and how to cut it into pieces that then make patentable inventions.
But also, the law is defining the digital innovation as a computer related inventions, and they defined some of the patentability requirements to protect these inventions. So I think that the question marks in for SMEs, for startups, for other inventors of the digital innovations, they are asking of mostly, oh, digital innovations cannot be patentable. So there are, it can be a rumor or something. So maybe we can explain what is the real patentability requirement for the computer related inventions. And the question is simple: are they patentable?
Yeah. Is software patentable? Yeah. So that's I think one of the biggest misconceptions in the whole IP topic. And it has been around ever since, and it is still around. And I'm always trying to do my best to really rid the world of this misconception that software is not patentable, because that's simply wrong. But it sticks still. So there's still a lot of awareness creation to be done. I guess it all comes back to, I mean, if you look at the legal texts, the European Patent Convention, and for example the German patent law, which is literally word by word, it's the same text. It says that certain things are excluded from patentability, and among that there's a list, like kind of a blacklist of things that are should be excluded by law from patentability. And it includes very abstract things like mental models, pure business methods, things like that, scientific theories, and also computer programs are on that list. And so everybody who's not so into the topic thinks, okay, there it is, software is not a patentable invention. But then there is this as such relative clause. So we could, talk for hours about the legal background about how this came about and why it is in there. But in practice, what the whole case law over the years and over the decades developed is a very practical approach, and that is just, in the end, to cut it short, you just have to ask yourself, what does the software do? Really, what is the purpose? And there has to be, that's the magic keyword, so to say. There has to be a technical purpose. The software has to solve a technical problem. Now, of course, the question is, what is technical? And I think, I mean, also here, I do whole 2-day workshops on that topic, case law workshops. But I mean, I guess everyone has a good gut feeling of, yeah, when something is technical, if you control something in the real world, of course, that's a technical kind of application. And if it is done in software, it is still technical. That doesn't make it less technical. And there are also other examples which are purely abstract. Maybe if you have, I don't know, an app which just lets you book calendar invites, that's maybe more of an administrative thing and not a technical problem solved. So I think at the ends of the spectrum, maybe everyone has a good gut feeling. And then, of course, in the middle, it gets interesting, especially for me as a patent attorney, because there, many things are not yet decided, in fact.
So, as I understand that this the patentability of digital innovations is not a question in only Turkey. It's all, of course, in Germany. You are hearing this misunderstanding of patentability on digital innovations, right?
Absolutely. Yeah, yeah, all the time. Yeah, especially in the German, yeah, not only in the startup scene, I have to say. I mean, even with traditional with established businesses from traditional industry sectors, I would say, who are who may have an own in-house patent department, right, filing solid numbers of patents for, let's say, mechanical products or for automation systems. They struggle. They know patent law inside out, but they struggle with the question now: what happens if our developers don't build physical prototypes anymore, but ever so often now, when they train machine learning models, can we still protect that with patents? So even those companies struggle with that topic in Germany here.
But we can say that there are some major or minor differences between the patent laws in EP, EU, in European Patent Convention, and also the United States. So, can we say that United States is more easy to protect the digital innovations, or is that true? That so Facebook has an advantage on that point?
That's really, yeah, I'm not so sure sometimes. I'm not so sure. What I can say is that at least the European approach, the European case law is quite predictable in, if let's say 80% of the cases of the application domains, you can pretty much look into the case law, and you will find earlier decisions which have decided on similar things, so you can draw conclusions on your case. So it's pretty predictable, except for really the borderline cases. There no one knows until, yeah, the Board of Appeal decides down the road. But I would say the European approach is pretty predictable, although it is tough. You have to convince really the examiner that you are solving a technical problem for whatever that is, and there is the creativity of the patent attorney is asked here. In the US, from my point of view, I mean, I'm a European. We are European patent attorneys. I can only give my experience from the outside. In my experience in the US, things are much less predictable. At least since we have this famous Alice decision. I think we have it for like eight years now or something. Before that, basically everything was patentable. The US never had this technicality requirement in that sense. And then with Alice, the pendulum really swung back, and many software patents were invalidated. And I think right now the pendulum is somehow, yeah, converging into uh, at least some American attorneys openly say that Europe is the toughest jurisdiction right now globally. Yeah, but you never know. It's all, especially in the software field, it's all in movement. It's all very dynamic, especially in topics like AI or machine learning based inventions. There's, yeah, still much caseload to be created, and no one really knows where it will converge, so to say.
Exactly. So maybe we can talk about the importance of protecting the digital innovations. So mostly I'm hearing that the companies mostly are asking that why I am paying these monies for protecting the innovations, my digital innovations. So we always say that look at the competitive environment in Europe, in United States. It's tough. It's very it's very hard. So the Spotify is trying to enlarge its patent portfolio. Even they are applying itself or they are purchasing the important patents from other companies. So it is really getting more important and more important to have a very strong IP assets, patent assets in the portfolio. So what do you think about what can we say to the startups and companies, SMEs and big companies, to convince them why they need to protect their digital innovations?
I mean, when you're talking about big companies, I think it's basically, I mean, they are mostly of them, most of them are already aware that patents are needed only already for the reason of this, let's say, balance of weapons, you know? I mean, and the big companies and also the tech giants, everyone has their big patent portfolio, and so you just have to have it to have, yeah, to play the game, so to say. With SMEs or especially startups, my experience is that many startups have kind of maybe the originally sometimes the wrong motivation to start getting into the patent game, to call it that way, because they think, okay, we need patents in order so that we can really aggressively exclude our competitors from the market, and we so because with a patent we can sue them, you know. And but from in my personal experience, that's maybe not the best reason for startups to start patenting their inventions, because I mean, on the one hand, it takes long to get patents, which you could then enforce by suing your competitors. Takes several years, so that's, I don't know, 3 to 4 years at an average. That's an eternity for a startup. Many startups are founded with the aim to have the exit already then. And on the other hand, it costs a lot of money, which you normally don't have as a startup, to really enforce your patents in court. But nevertheless, what clever startups really use their patents is the other more the business, not so much this exclusivity aspect, but on the one hand the business aspect, because I mean, in the end, what patents can do is they turn the IP, which is for digital business models, is all in the heads of the founders and the developers. You know, I mean, a digital startup doesn't have any machinery, any, I don't know, hard values, but the value is really the knowledge of the people, and knowledge is free. If the developers leave the startup and found the next startup with the same business model next door, they can do the same thing uh, when they take their ideas with them. And patents help turn those intangible ideas into tangible business assets in the end, which can be owned and which can be transferred to the company. And you know, yeah, you know all that. So that's the business aspect. It then allows to evaluate that ideas, to put a price tag on it in the end, you know, to which goes into the valuation of the company in the end. And of course, it's the long-term perspective is really making the company attractive for acquirers if it's an exit strategy, or for investors, because of course investors want, what do they want? They want security. They want to know, will can the business idea get copied easily, and does the company infringe any other third party rights? And there patents play a big role, of course.
Exactly. The VCs are started to ask mostly the strong point of the patents in the portfolio of the startups
Mhm.
before the investment. So the startups are trying to, or SMEs are trying to understand that yes, our IP assets will attract the fund from the investors. So investors are really like the patents because they believe that if they have a really good business model, and if the company has a really strong patent, so they will really create a competitive advantage in the targeted territory. So we are always convincing the companies to to define the real value of the patent. So there are something in the paper, but they need to understand that this paper will create a value of on their business model. So um, it's good to hear from your perspective. It's same also.
One other point, maybe if I can add that comes to mind is really I'm it sounds academic, but I'm seeing this all the time with my startup companies. As soon as we start, let's say, when a startup comes to me which doesn't have patents yet, and they wanna get into the topic because their investors are asking for it, and as soon as we start investigating the portfolios of their competitors, it's like an aha moment. They see, okay, that's what the competitors are up to. I mean, of course, the solid startups know what their competitors are up to, but then they can look into the published patent documents and really see nitty gritty the details, what of solutions they are most probably working on. Of course, that lags always behind 1.5 years because the patent applications are only published 1.5 years after filing. So you can also only see what your competitor is filing 18 months with an 18 months delay, but it gives you a good impression of what they are up to. And I've seen it numerous times that uh, the more the developers then really, yeah, go through the patent information of their competitors, they come up with, yeah, nice workaround solutions, and it kind of stimulates their inventive activities.
Exactly, and other point that the companies are assuming that one patent grant will protect them their products forever. So they need to understand that they need to create a patent portfolio on a single product. So what do you think about that point?
Absolutely, that's absolutely paramount. Yeah, yeah, that's maybe another big misconception that is around. And many startups, when they come to me, they say, "Okay, here's our let's." So in the mechanical world, they would say, "Here's our product. Here's our a prototype of it. Can we patent it?" And in the digital space, they would say, "Okay, here's our that's our platform model which we are trying to build here. Can we patent that platform?" And the answer is always no. You can't patent the thing, the whole thing, the product. What you can patent is the technical small technical building blocks under the hood, so to say, that make up the whole product. And of course, the trick is to find those technical building blocks which the customer is paying for, which result in the best possible solution for which the customer is paying. Because if you block those, your competitor can only offer the second best solution. And it's always, yeah, in the end, multiple little building blocks you are protecting. So you need multiple patents. And also, you have to, as a startup, I would say, you have to get rid of the thinking that, well, we need to get an enforceable patent as soon as possible, because as I said, you as a startup, you will never enforce the patent. You don't need the enforceable right that much. What counts is really that you get a good filing, a good patent application on file, um, for various reasons. Has to be as quickly as possible, and then to postpone the further costs possibly as far as possible into the future, because maybe the investors will then pay for them, or you will have sold your company by then.
So you said that there should be a good patent application. That's the question is coming for that. So most of the companies are trying to apply a patent applications by their own instead of working with a experienced patent attorney. So in that point, maybe they can the decrease the cost, but at the end they are releasing their product, they are launching their product in the market, but the patent which is written by the owners of the company will not protect the product in the market.
Yeah,
So good
exactly.
good patent application is the critical. So what is the dimensions of the writing a good patent application?
Yeah, the secret is that yeah, writing patents is not only science; it's also a considerable portion of it is really like an art, or at least there's much experience that goes into it because you must have seen many patents. For drafting good patents, you must have experience how to enforce them later on, because then you will see what can go wrong later on. And yeah, things that can go wrong are, for example, yeah, I mean, if you, that the claims in the patent application in the patent define the scope of protection you have, right? The extent of what is protected, how broad it is, or how narrow it is, how specific. And yeah, if the claims are too narrow, you are only protecting maybe exactly the version of the product like you implemented, but the competitor only has to change one little parameter and is out of the scope. That's of course then the patent is really worthless. On the other hand, if the claims are really overly broad, you will not get a patent at all because the examiner will send you home, because yeah, it's too broad. And also what can go wrong and what almost always goes wrong, and that's oftentimes overlooked, is if someone without experience writes their patent application. I mean, the patent claims are only there to define the monopoly for the patentee. But the basic patent deal says that in return for getting that monopoly, the patentee has to reveal the invention to the public. So the specification of the invention, the whole text and the drawings, has to be so detailed that it really has to be some kind of an assembly manual, I would say. So any third party reading the application must be able to build it. That's the level of detail you have to provide. And if you don't have that detail, if you just explain the invention very conceptually, it can be that it is not granted at all because there's no enabling disclosure and the patent examiner won't grant you a patent. But on the other hand, and this is so oftentimes overlooked, if you reveal too much, there can also be problems because every patent application is, as I said, published after 1.5 years, regardless of the fate of whether there is a patent granted in the end down the road or not. So, 1.5 years after you file your patent application, everyone, including your competitors, can read it, can Google it, and can read it. And so, there's a fine line of what you need to disclose in order to get the patent. But of course, too much is unnecessary. You shouldn't also educate your competitor on the best possible workaround solution already in your patent application. And that's really difficult to figure out in each individual case.
It's really a perfect balance between the
Yeah,
between the narrow and broader of the patent claims, right?
yeah,
So
absolutely.
it creates a need of help from an experienced patent attorney, I guess.
I mean, in the end, it's just a matter how professional you wanna run your company. I mean, if you really have a solid business plan, and if you have a plan to really build a solid company, you also wouldn't do your tax declaration, the corporate tax declaration, on your own probably. And the same goes with IP protection, of course.
Exactly, exactly. So mostly in Turkey, the companies are starting to getting advantage of the patent box. So if they have a granted patent and if they are using this patented technology in a product, if they are selling this product and if they are generating an income, they can get an advantage of corporate tax of this the patented invention. So this is the 50 percentage of tax advantage in Turkey
Oh,
now.
really? Oh, that's interesting. Cool. I didn't know that.
So tax advantage is the 50 percentage, but it is calculated by like this. If you're having a granted patent on a product, and if you are selling this product, and the law says that you need to calculate the real value of the patent in the product. So it and the question is how. So the companies need to develop a patent valuation report for their patents which they use in the product, and then they can calculate the tax advantage they can ask from the government.
Interesting. Interesting. I didn't know that because yeah, I think we don't have something like that in Germany. So I'm not aware of any tax incentives for filing patents.
But it's not for the filed patents. It must be a granted patent. And yeah, but the companies are not really fully aware of this advantage because they don't know how to calculate the real value for asking the corporate tax advantage. But it's growing, so we need to push them to be aware of this kind of advantage. But another question or another problem for mostly the companies in Turkey, they are not aware to um, to create a freedom to operate analysis before exporting to the other countries. So it's really important problem because we saw that some of the companies are really infringe in the specific target countries, mostly in United States and Germany. So what do you think about these, the awareness level of the German companies? Is it same or more well-educated companies when they are trying to export?
For SMEs and startups, it's yeah, there's still, like you said, basically there's still much awareness work to be done, especially this FTO question you brought up. That's interesting to me because that's also there's many misconceptions among my German clients because yeah, many of them think filing their own patents gives them freedom to sell the product, and I mean that's not true. Yeah, that's one of the other big misconceptions. Yeah, yeah. So you have to educate those companies first that patents really only give you a right to exclude others from doing what's protected by the patent, but they don't ensure that you don't infringe other patents. So those are really two different things. Yeah.
Exactly. But they are supposing that, as you said, I have a patent application, so I have a real power when I export to another countries. So they don't understand the sub components of their product. Maybe they can infringe another patent owner. Yeah, it's a dangerous thing.
Talking about yeah, different countries, that's also one thing that's, I guess, specific to digital innovations is really the borders. I mean, digital innovation is global. I mean, if the business model is a cloud platform and your customers are probably it doesn't matter where they are on the planet. That doesn't play any role technically, and doesn't also play any role where the servers are located. But on the other hand, patents are in the end territorially limited rights granted by individual countries. And there's also, this goes back then to the skill of patent drafting. You can do all sorts of mistakes here if the if the invention somehow involves a distributed system which has some portion that runs on the server in the back end, and some part of the innovation happens on the smartphones of the users, for example, or in my digital signage example, in on the display in at the customer's side. So you really have to be careful how to draft your patent so that you protect the individual parts so that you can enforce them later on.
Exactly. In the last part of our episode, maybe we can also make a point on the technology trends. As you said that, artificial intelligence is growing, expanding, machine learning is expanding, metaverse technologies, AR, VR, mixed reality, smart glasses. Every these technology trends includes the digital innovation. So we will live in a digital environment, maybe metaverse environment in the near future. So, uh, what do you think about these patenting procedures for these technology trends? So, more companies will need patent applications, patent protections for their digital innovations because the trends are going on that way. So, how do you see that? Because the Facebook has a really huge um, portfolio. Apple has a huge portfolio. Most they are developing digital innovations. So, what is the next step for this environment?
Huh, that's a good question. Open question into the future. Let's see what the future brings. I mean, yeah. I don't think that the fundamentals of the patent system will change. I think I don't know. I don't know. I'm not sure. I mean, yeah, I have to admit that the patent systems of the world, at least the European one, our home turf, I think it's is moving slowly. I mean, they are always adapting the this notion of technicality, as I was explaining beforehand. So where are the boundaries? What should be considered technical and what not? Where should be the borderline? And that's also important that this stays flexible, and that's our job as patent attorneys to kind of push the borders into the right direction for our clients. But I think the fundamentals, many some people often criticize that it takes too long to get patents, or the maximum lifetime of 20 years of a patent is doesn't fit into digital innovation anymore because it's so fast paced that a monopoly for 20 years is just too long. Those are heavily political questions in the end, and I'm not sure if those will change anytime soon, because you would have to change it for the whole patent system. I mean, it will probably never happen that we have different rules for digital patents compared to other types of patents. Yeah.
Exactly. Maybe in the next near future, maybe we will talk about the patent protection in the metaverse environment.
Let's see. Yeah, maybe.
Yeah, of course. So that we are in the nowadays we are talking about the inventorship of an AI. So we are talking about how the blockchain system will change the ownership, how will change the blockchain will change the transaction of any assets. So we are talking about the NFTs or something. So I am sure that you are applying patent application regarding these technologies as well. So we will see. So I'm really curious about the next future.
Me too. Me too. And it never gets boring. Yeah.
Yeah. So Bastian, we are now in 14 minutes. I really enjoyed with this conversation. I hope the audience, the followers of our podcast session will learn about digital patents and its procedures and the big picture of the real advantage on the patent protection. And I will also put your YouTube account link in the description. And also, you have a newsletter, right? Maybe in the last point, we can mention about your newsletter.
Oh, thanks. Yes, I do actually. Yeah. So yeah, the best way maybe to look for things that are published is maybe YouTube. Yeah, and on LinkedIn, I'm quite active. So if you just Google me, you will find my LinkedIn account also. And yeah, for people who even want more, I started to write a daily email. So daily-ish from Monday to Friday. Sounds a lot, but people actually read it. Yeah, believe it or not. And it comes out every day from Monday to Friday, and it's every day just a short a thought or a link or yeah, a useful video, always in around the topic of digital innovation.
Yeah, I am receiving the daily mails from you, so I really getting advantage on that. So thank you for publishing this newsletter. So keep going on.
Well, thanks for reading it.
So, Bastian, thank you so much for attending this podcast session. I hope maybe we can record another podcast session in other topics. So, I really miss Munich. I hope we will meet in person in different cities in Europe.
I hope so too. Absolutely. So thank you very much, Mustafa. This was a pleasure. Thanks for having me. It was great fun.
Thank you so much. So, I'm closing the session now. So, this is the end of Patent Effect podcast session. So we were together with Bastian Best from Munich, who is an European patent attorney. So we learned about the digital innovation patents and some of the procedures, importance of the real strong patents. So you can also reach him from the links, the websites or YouTube account of the Bastian. I'm putting these links in the description. So we will be together again, the audience, in the different topic in our podcast. So see you in the next episode. Bye bye.